Well, at 6 o'clock, we're going to go ahead and get started here to make the most of everybody's time. My name is Shelby Benson. I'm the Director of Development and Pro Bono for the Mecklenburg County Bar. I want to welcome each of you who are joining us tonight. We have Akeisha Resper. She serves as the Pro Bono Committee Chair for the Mecklenburg County Bar this year. And we have Jonathan Slager here from Legal Aid of North Carolina, and they're both here to provide us with some valuable information regarding landlord and tenant disputes and how that works through the court process here in North Carolina, specifically Mecklenburg County. We hope that this information proves helpful to you in case you ever go down that daunting road. This gives you a little bit of peace of mind and a little bit of sure footing to get started on. We're just going to ask, we're going to do the Q&A function of our event later in the presentation. But if you happen to have any questions as we go along, please feel free to submit that into the chat function at the bottom of your screen. You'll see the little chat icon down at the bottom. And we'll be happy to take a look at those as we go along. But without further ado, we also have Natasha Robinson joining us. She is another attorney here in Mecklenburg County who works in landlord and tenant disputes as well. So welcome, Natasha. And I think we're going to go ahead and get started. So I'm going to share a PowerPoint presentation that we put together to kind of guide us through our topics for tonight. Technology is always a fun thing, isn't it? Here we go. And if everybody can see that okay, I'm going to go ahead and get that going. All right, and we'll take it away, Akeisha and Natasha.
I can start. If you could just advance the slide, please. Okay, so to get started, the term for eviction in North Carolina, the legal term is summary ejectment, but essentially that's what it is removal of the tenant. And there are 4 statutory bases you'd have to meet in order to be quote unquote eligible to file for an eviction as a landlord. So one of the more common ones is the tenant isn't paying rent, right? So that is one ground. Or the tenant may stay longer than the lease allows for. Their lease is expired or has ended and they are still physically on the premises. Another grounds for a landlord to bring an action for eviction is if the tenant has breached the lease agreement under some provision of that agreement. And there's been no cure, no changes to the breach, and so the landlord is seeking additional action. And then finally, there is what's called like an expedited eviction process for scenarios where it's discovered that the tenant is involved in criminal activity, and there's specific types of criminal activity that are enumerated in the statute, but it gives the landlord a faster way to evict the tenant without having to do certain processes like giving notice. Next slide. So the actual document that's filed with the smallest claims court is called a complaint and summary ejectment. And we've hyperlinked to it here. But basically, it asks the landlord to fill out all the reasons and a lot of details around what's happened so that it's very clear to the court what the issue is. Because it is brought in small claims court, there is a cap if the landlord is seeking financial damages at $10,000. And to file the form and to get essentially the lawsuit started, there are filing fees that need to be paid. So the timeline, as far as once the clerk actually receives the complaint document and sets a hearing, is usually within about a week. And then the process involves that the clerk will then issue a summons, so pretty much notifying the tenant of the lawsuit and where the time and date of the hearing. The tenant can be served in different ways, depending on what the landlord chooses. So it can be by mail, it can be by a designated delivery service, or it can actually be by a sheriff. Now we're going to transition to Akeisha, who's going to talk about what happens when you actually get to court and take it from there. So I'll hand it over to you, Akeisha, please.
Thank you. You'll have to excuse me. Someone decided to start cutting the grass as soon as we begin this presentation. So if you hear noise, please try to ignore it. Or if you can't hear me, just let me know and I'll try to talk louder. But as Natasha said, I'm just going to briefly go through what happens once the complaint is filed. This is just a general overview. Depending on your set of facts or what's going on in your case, it may slightly differ, but generally this is how things go. So first is trial, the procedure. So once you file the complaint, you're also going to complete a summons, which will list the date and time of your trial. You're to appear in that courtroom, and generally the magistrate will go through the docket, which is essentially what calendar call is. So they'll call, basically take roll to see who's present. And then when it's your turn or when your case is up, you'll have the opportunity to present your evidence. So generally how it goes is the plaintiff, which is the person who filed the complaint, which would be the landlord in this case, they would present their evidence. So that may consist of calling witnesses or you yourself testifying, presenting supporting documentations. So you would want a copy of the lease or whatever document you're claiming they're in breach of. Any notices you issued, if there's anything involving damages or some other claim, you would want pictures and a ledger and account summary showing what's been paid, what's been charged. Then the defendant will get a chance to cross-examine any witnesses you may call. And then the same thing happens. The defendant will get the opportunity to present evidence, call witnesses, present documents in their defense. And if they have any counterclaims after the close of your evidence, they'll get the opportunity to put on evidence to support any counterclaims they may have. You can go to the next slide. Thank you. As far as evidence, what evidence do you need to bring? Well, the lease, if you're alleging that they breached the lease, or tenant, summary judgments require the existence of a landlord-tenant relationship. So anything you have to show that there's a landlord-tenant relationship, the easiest thing to present is the lease, a written lease, if there's a written lease. If there's an oral lease, you would want anything that helps support that. So anyone may have overheard the conversation that you had when you agreed to whatever terms you agreed to. You yourself testifying as to what terms you orally agreed to. And prior to filing the complaint, you'll have to issue notices, and that all depends on what your lease outlines. If your lease doesn't have what's known as a forfeiture clause, you'll need a 10-day notice to pay or quit, a final demand for possession. If it's a situation where it's holdover, where the tenant is staying beyond the time they're allowed to in their lease after the lease has been terminated, you would need the notice to terminate tenancy or the notice to vacate. And if your lease has an option for them to cure any lease violations, this is most often seen with like housekeeping violations or something that's curable or redeemable, and you issued a notice to cure and they failed to cure, you would want to present that as evidence as well. Like I previously stated, in all non-payment cases, you would want some type of ledger or accounting showing what's been charged and what's been actually paid. Any photos, if you're also including a claim for any damages, or photos to help support your claim that they're in violation. Like I said, like a housekeeping violation is probably the most common one. And any other evidence, you would want to make sure all your documents are printed out so you're able to present them to the court. No electronic evidence is permitted in small claims court. So after everyone has the opportunity to speak and put on their evidence, the magistrate will enter a judgment, and it'll be on a form what that's known as judgment action for summary ejectment. The judgment is generally entered in open court, so that just means after the conclusion of all the evidence, the judge will let everyone know their decision, who they're ruling in favor of. In most summary ejectment cases, there's basically two prongs. They're going to say whether or not you have been awarded possession, and if it's a non-payment case and you have a money owed claim, they'll say whether or not you received a money judgment. Okay. So after the entry of the judgment, either party will have the opportunity to appeal. That clock starts the day after the judgment is entered. So day one is the next day, and either party will have 10 days to appeal the judgment. When you appeal the judgment, you're appealing it to district court, and you'll get what is called a trial de novo, which just means a new trial. There are a number of requirements the appealing party will have to meet in order to appeal. You have to file a notice of appeal. If you're a tenant, pretty sure Mr. Slater will get into that a little bit later as to what else is required. If the tenant appeals, they are required to pay a rent bond, and usually that's just the monthly rate of rent, and they'll pay that directly to the clerk instead of you while the appeal is still pending. And that's all. So it was all for me, at least. Now, Mr. Attorney Slater will talk about tenants and what you all need to know.
Thanks. Like Shelby mentioned, I am a tenants' rights attorney, so my information is biased, but at the same time, there's a lot that both landlords and tenants can learn from this. The first thing, even though part of the eviction process and the rules for the tenancy is covered by law, the lease is really the main thing that's going to cover most of the landlord-tenant relationship. So regardless of whether you're a tenant or a landlord, it's important to really read the lease, because a lot of times the lease will answer questions. It'll tell you what landlords can do or can't do, and what tenants have to do or can't do, things like that. It'll tell you about a lot of the eviction process. Sometimes, if the lease doesn't have information about the eviction process, it's going to fall back on what the North Carolina statutes say. But at the same time, it can be supplemented by whatever's in the lease. So it's really important that both parties are aware of what's in the lease. I know some people get a lease and they put it in the trash, or they put it in the junk drawer, or who knows what happens to it. And then when it's time for an eviction, or when they want to know what their rights are, they can't find it and they just don't know. So it's really important to keep the lease and to know what's in there. Next, it's important, I know I'm kind of skipping a little bit of information, I'll get to the slide in just a minute, but it's important that both parties communicate. If you can avoid going to court, again, as either party, it's probably the best, because court can be expensive. If you've got an attorney or even just missing time from work, both parties lose when you get to the court process. So if you're going in front of the magistrate, you've already started kind of losing, and you've lost some of the opportunity to resolve this without going to court. And part of that is also the ability to negotiate. So sometimes that means, if things aren't going well in a landlord-tenant relationship, maybe y'all need to talk about before going to court. Maybe the tenant wants to leave and break the lease, but the landlord can negotiate by saying, hey, I won't file this case if you pay part of the rent, or maybe if you want to stay, let's find a way to get some financial assistance for you to try to catch things up. So both parties really need to be involved and invested in the relationship going forward, because a relationship, whether it be business like landlord-tenant or a personal relationship, it's always just as good as the people make it. So now I'm going to talk about the evictions a little bit more. Evictions must be judicial. So regardless of what the lease says, every eviction has to start in the court system. And like was already discussed, that starts with the complaint and the summons. But what a landlord cannot do is to start the eviction themselves. And that means something like either switching the locks so that a tenant can't get into the apartment, or turning off the utilities, the electricity or the water, trying to really make it difficult for the tenant to stay in the home. We've even had cases where the landlord took off the front door and just took it and removed it from the property. And, that was basically their way of saying, if you're not going to get out, then wild animals can get in. And that was kind of depressing. Because again, it just leads to a breakdown in the relationship. And that's dangerous for landlords if they try to do things themselves, because there are statutes which prohibit this. So typically, if that is something that occurs, a tenant could go and get a temporary restraining order. And that stops the landlord from doing whatever it is they're doing, or makes them do what they're not doing. And if the landlord continues to not follow the instructions of the court, it can lead to things like being put in jail for being held in contempt by the judge. So it's really important to do this the right way. Go through the judicial process. Like I said, there are things that are required by law, and going through the court process ensures that everyone is following the right rules, or everyone knows what's going on, and doing things the right way. Next slide, please. Talked a lot about the court process already. For a tenant's perspective, there are some defenses that can be used. One of the main things that we use in court is the requirement for proper notice. At the very least, the landlord has to tell the tenant that they need to leave. It doesn't have any magic language. It just says, you need to get out, sometimes by a certain date. Sometimes, they include the time in there. They might say the end of a lease, but there has to be some kind of a demand for possession. In addition to that, because that applies to everyone, but subsidized tenants can have even more defenses. There's a Violence Against Women Act, which requires special notice. Even if tenants are not victims of domestic violence, landlords still have to provide special notice to subsidized tenants. And additionally, subsidized tenants can have the right to a grievance hearing. The timeline for that is very important, because typically tenants only have 10 days to request a grievance hearing. So they need to move on that as quickly as they can once they know that the landlord is trying to evict them. Other defenses, like mentioned earlier, is the right to cure. We see this a lot. It's even in non-payment cases, but particularly the first box on an eviction. So this is not really where there's a breach of the lease for non-payment. It's just where the lease does say that, try not to get too technical, but basically that if it's just for a non-payment, the tenant does have the right to pay the money that's owed. And that's not all the fees, it's basically just the rent and court cost. And tenants can do that all the way up through and including the eviction trial and small claims court. We've had some tenants walk into court with a stack of money orders and slam them down on the landlord's table and say, basically, here's the money you wanted. Everyone can see I'm paying it. So there's no dispute of whether I paid it or not. This is the money you wanted. And depending on which type of eviction you're dealing with, that can be enough to overcome it. Tenants also are protected by the Fair Housing Act. So this prohibits discrimination based on a number of factors like race, gender, national origin, disability, etc. So basically based on that, landlords cannot discriminate. They can't treat people differently for those reasons. In addition, tenants that have a disability can request a reasonable accommodation. So that means that if a tenant is, we'll just use an example, that they need a emotional support animal, landlord should allow them to have that emotional support animal. There's no extra charge for that. Even if there's a pet fee, there's certain types of animals like a service dog, regardless if the landlord wants to charge a fee because that's a pet. And I understand that perspective, but at the same time, if it's for a disability, there's not going to be an extra fee based on that. Or something like a special parking space. If someone can't walk very far, they might need a special parking space near the door of an apartment. And as long as the request is reasonable, so it's not going to be like, I need a $60,000 elevator built so I can get to my apartment. But it's, if I need a ramp to get to the stairs or something like that, then a landlord will generally need to accommodate them. Another type of defense is a debt collection violation. So landlords, you don't really think about this, but landlords are debt collectors because every month they want the money. So because of that, there are special laws that prohibit unfair debt collection. So things like that might be improper fees. You know, if the landlord is trying to charge a fee that's not included in the lease, they can't do that. Or if they're trying to charge a late fee, that's at the wrong time. So in North Carolina, late fees need to be, they can be assessed after the 5th day of the month generally. A little bit of a gray area, but that's generally how magistrates see it. So if a late fee is charged before the 5th day, then that's an improper fee. Or if the fee is too much, because in North Carolina, late fees can only be 5% or $15, whichever is higher. So if a landlord wants to charge more than that, it's not allowed by the statute, and that becomes a debt collection violation. And that's really important because for tenants, they don't have a lot of power. You know, the landlords often present this lease and it's a take it or leave it type of thing. And tenants, you know, if they want to stay there, they have to sign the lease. They don't have a lot of negotiating power at that point. But regardless of what the lease says, if the landlord is trying to do something improper by charging the wrong fees or fees at the wrong time, the law can allow basically a penalty for the landlord. So tenants can get back between $500 and $4,000, depending on the circumstances there, for any debt collection violation. And that adds up very, very quickly, obviously. It can be for every violation. Typically, magistrates award things on the low end, so it might be just $500 for each fee that's improper. But again, that still adds up, particularly over time. And another important defense is when the landlord has filled out the complaint incorrectly. So as was mentioned earlier, there are 4 boxes. There are 4 main reasons why a landlord can file for eviction. A lot of times landlords, you know, without having an attorney, they think they're checking the right box. For example, the first box in the complaint is for non-payment, but depending on the way the lease is written, it might actually be a breach of the lease. So there might need to be a different box that's checked. And so if a tenant really pays attention to what's going on or talks with legal aid, they can get an idea of whether the box is correct or not. And I assume, landlords can talk to their own attorneys too. But like I said, that's not the type of law that I practice. Next slide, please. Major issue that we have with tenants and landlords is repairs and habitability. So by law, landlords have a duty to maintain the home. That means, if there is a problem that's not really of the tenant's making, or even of the tenant's making, which is a slightly different issue, the landlord needs to come and fix it. It can be like if it's in a common area, typically the landlord is responsible for it at all times. But if it's in a area that is just for a certain tenant, the tenants need to notify the landlord in writing, because a landlord can't fix what they don't know about. So once the landlord gets a notification in writing, they have a reasonable time frame to make any repairs. The law does not explain what reasonable means. It's kind of up to each circumstance. So if it's a heater that's not working in the middle of winter, that probably needs to be fixed pretty quickly. But if it's a leaking pipe, well, that's not that important. Maybe that can be a few weeks, maybe even a month or two, because that's not like a life or death situation. So that reasonableness needs to be considered in how quickly a landlord is required to make a repair. So that's the landlord's duty, but at the same time, the tenants still have the duty to pay rent. So even if there's something wrong with the home and the landlord's not fixing it, the tenant can't just stop paying rent. They got to keep paying the rent. The proper procedure would be going to small claims court and filing a specific, basically you can request something called rent abatement from a landlord. And that's like a rebate in the rent that you've already paid. So that means you need to keep paying rent. Tenants should keep paying rent regardless of whether the repairs are being made, and then you can get a judge to say, well, you paid more than the place was worth, you should get a refund based on that. And another tool that can be used is code enforcement. Code enforcement will come out and inspect a premises. There are quite a number of inspectors that will come out and just look at all the different problems in a house. So a tenant can call 311 and have someone come out. And if the tenant's at the home at the time of the inspection, they can direct the inspector's attention to certain problems. But the inspectors will look for any number of things that are going wrong, things like wiring, infestations, appliances not working, mold, things like that. But on the topic of mold, the inspectors aren't generally going to say that mold exists or not, because that's kind of outside of their specialization. They can note any damages from mold, but they won't really talk about mold because mold is a really complicated topic. There we go.
So I wanted to include a slide on here as well, for folks that are joining us that might not know some of the local resources that are available. Of course, you can always reach out to a local attorney who practices in landlord and tenant disputes. Some attorneys specialize in residential landlord and tenant disputes, and others focus more toward business landlord and tenant disputes. So you just want to make sure when you're looking up an attorney to do that research, double check their website and make sure you're calling the correct type of attorney. If you're not sure, the Mecklenburg County Bar and the North Carolina Bar Association both offer lawyer referral services on their websites. So for the Mecklenburg County one, that would be mecbar.org/LRS. And for the North Carolina Bar, that'd be www.ncbar.org, public resources, find a lawyer. Depending on which service you use, there might be a fee to request a referral to an attorney. And from there, if you decide to proceed with a consultation with a lawyer, their fees might vary. So you just want to make sure that you check with that. And if you're not in a place where you can afford a formal consultation with an attorney, there are some other pro bono resources and self-help resources that would be helpful. As Jonathan mentioned, legal aid is a resource that is available for all 100 North Carolina counties. Legalaidnc.org. You can also look up what office is closest to where you are located. Charlotte Center for Legal Advocacy specifically focuses on the Charlotte metro area. Mecklenburg County Courthouse offers the Self-Serve Center, and they do provide some limited assistance. In this case, it would be for small claims matters. They can help guide you to the correct paperwork if you are filing as a pro se litigant, meaning you don't have an attorney assisting you. They will not provide you legal advice, but they can make sure that you have the right paperwork in hand if you choose to go that route. Some additional resources are also available through lawhelpnc.org. They provide a whole host of legal guides for the public for a variety of topics, including landlord and tenant.